Good afternoon and welcome everybody to today's webinar on HVNL statutory instruments consultation. My name is Aaron De Rosario and I'll be emceeing and presenting today. I'll also be joined later in the presentation by Lisa Green from the National Heavy Vehicle Regulator. I'd like to begin this presentation by acknowledging traditional owners of the various lands upon which we are meeting and pay my respects to elders past, present and emerging. I'd also like to thank everybody for making their time today. We are going into a very important part of the HVNL process. So I'm going to go through quickly what today's agenda will be. I'm going to commence with a quick update on where we are with the Heavy Vehicle National Law and the reform process. Then quickly why we are meeting today, and followed by an overview of the various statutory instruments upon which we're consulting. And then finally, we're going to have a question session. So we are going to wait to the very end of the presentation before taking questions, so that we can make sure that we get through all of the content. You'll be aware that we are in fact going to cover off all the statutory instruments today. Based on some previous presentations, we believe we're going to be able to get through all of that content, but we do welcome any questions you might have towards the end of the session. So I might get underway with a quick overview on the HVNL and where we are at the moment, the Heavy Vehicle National Law. Many of you will be aware that over the years 2023 and 2024, ministers have been endorsing a range of recommendations coming out of the Heavy Vehicle National Law Safety and Productivity Program, designed to simplify the law and contribute towards some productivity and safety benefits. Those particular recommendations that they've endorsed has led us to having a draft Heavy Vehicle National Law Amendment Bill and Regulations, and that package of law is currently before the Queensland Parliament. Queensland, of course, is the host jurisdiction for the Heavy Vehicle National Law. Subject to that law being passed through the Queensland Parliament, and we have a reasonable level of confidence that that's likely to be later this year, we expect that the changes to the law will take effect in mid-2026. These changes will include some important changes to accreditation, and that's one of the really key reasons we are talking to you today. We can move on to the next slide. The main reason we are here and having this presentation with you today is to talk through a range of statutory instruments. Statutory instruments are documents that have to be approved by ministers, and they underpin and support the operation of legislation. In this case, we're going through a range of statutory instruments that will support the updated Heavy Vehicle National Law. These statutory instruments will provide very clear guidelines for how the regulator exercises powers, and will outline some of the expectations of industry representatives or industry members seeking to get accredited under the National Heavy Vehicle Accreditation Scheme. So we're going to be looking at 4 statutory instruments today. If you could progress the slide, thank you, Michael, that will be supporting the Heavy Vehicle National Law. Those 4 instruments are a Safety Management System Standard, Ministerial Guidelines for Heavy Vehicle Accreditation, a Ministerial Standard for Alternative Compliance Hours, and finally a National Audit Standard, which has been developed and will be spoken to you today by the National Heavy Vehicle Regulator. The reason we consult on these instruments primarily is to make sure that the instruments are clear, practical, and importantly consistent with decisions that ministers have already been made. We're currently open in consultation, and we will be open for consultation through until Monday, the 1st of December. Feedback we receive, and we'll be receiving feedback hopefully from industry as well as government stakeholders, they will inform the final drafting of these instruments before they go to Australia's transport ministers to be approved. So, with that background covered off, let's talk about our first statutory instrument. First one we're talking about today is the Safety Management System Standard. This establishes the minimum safety management requirements for accredited operators under the Heavy Vehicle National Law, and it provides the foundation for accreditation decisions and safety assurance decisions made by the National Heavy Vehicle Regulator. So this document will set out a standard, a performance-based standard that will outline what a safety management system needs to contain in order to be fit for the purpose of accreditation. And by way of background, under the changed law, all accredited operators will need to have an approved safety management system that's been reviewed by the regulator. The safety management system standard that we've got will define 5 outcome areas in the areas leadership and commitment, risk management, people, assurance, monitoring and improvement, and safety systems. These are the kinds of areas that the SMS standard will be looking at or will be specifying requirements for operators to demonstrate compliance with. Importantly, however, the SMS standard does not specify you need to have your safety management system in a particular format. It doesn't describe what headings it needs to contain or how it's outlined. What it describes instead is the kind of content it needs to cover off. It's intended that the SMS standard will allow flexibility and scalability so that it can accommodate operators of different sizes and complexity. And it will support the management of public safety risks under the Heavy Vehicle National Law and promote continuous improvement so that a safety management system doesn't just set a baseline standard for safety, but helps improve that over time. Importantly, the safety management system, while it contains a range of descriptions of what a safety management system needs to contain, it also has a very important schedule, Schedule 1. This schedule outlines the evidence requirements that will form part of the standard and set out the evidentiary expectations that operators need to meet in order to demonstrate compliance with that standard. The SMS standard, again, it's a critical document for operators that wish to be accredited. It outlines what a safety management system needs to cover off and address in order for the regulator to be able to validate that the safety management system meets the required standard, and it will work very closely and link very closely to the National Audit Standard that will be spoken about a bit later. We can move on to the next slide. There's a couple of things that we are seeking to get from industry and from other stakeholders in relation to the safety management system standard. First of this, is the standard practical, scalable, and proportionate for all operators? Some of you on the call today will represent larger organisations that will be able to have sophisticated systems or more sophisticated systems for managing risk. Others of you will be smaller operators, and the expectations on smaller operators are quite different. So we need to ensure, and we're looking for feedback as to whether the standard that we've described here and the standard that we're consulting on is scalable for different kinds of operators. We also want to make sure that the performance outcomes, in fact, all the content of the safety management system is clear and easily understood. So if we've got performance outcomes, are they described in a way that means you know what you need to do in order to develop a safety management system? Similarly, we want to make sure that any evidence requirements that we put into the standard are appropriate. Again, this is particularly important for ensuring that we know that the safety management system can scale from small to large operators, and that we're not making the system too burdensome for some or insufficiently robust for others. And then, of course, we need to ensure that the design of the standard effectively aligns with the new accreditation framework that we've put in place as part of the changed law. So we're looking for you to go through the safety management system standard, read it through, and provide us with feedback about whether you feel that that document is fit for purpose and whether there are any areas where it is unclear. If we move on to the next statutory instrument we're talking about today, it's the Ministerial Guidelines for Heavy Vehicle Accreditation. These guidelines are a set of guidelines that the National Heavy Vehicle Regulator must comply with when making accreditation decisions. So whenever the NHVR is granting accreditation, renewing accreditation, or cancelling accreditation, it needs to ensure that the decisions it's making are consistent with the ministerial guidelines that it provides. This ensures that accreditation decisions are consistent, transparent, and risk-based. So some important things to note about the ministerial guidelines. They are binding on the NHVR, as I've already said, whenever they're making an accreditation decision. They cover the process of granting, renewing, varying, and cancelling. And it sets forth the criteria that operators will need to, the criteria and evidentiary requirements that operators or applicants for accreditation will need to meet. It also includes some arrangements for transitional administrative provisions for when we shift for operators that are currently accredited under the NHVAS to transition across to the new scheme and the modified scheme. An important point for anybody who happens to be an existing accredited operator, your accreditation will remain in place until such time as it expires or 3 years from the date of the new law taking effect goes by. So you will not be immediately required to shift across to the updated NHVAS system. If we look at some of the questions and matters that we're interested in relation to the ministerial guidelines, What kind of information and what kind of feedback are we seeking? Again, as with the previous document, we want to make sure that the guidelines are clear and practical, that they're understandable and that they're scalable for different kinds of operators. Are they consistent with ministers' agreed policy intent? In other words, are they consistent with previous decisions that ministers have made? And are the assessment and evidence requirements achievable for operators of varying sizes and complexity? Again, and we will keep reiterating this, it is our intent that accreditation should be accessible for small operators through to very large and complex operators. We need to make sure that the requirements we put in place in terms of guidelines and in terms of other requirements we might have in place are requirements that can be met by different sized operators, and that we're not unfairly or inappropriately making it too difficult for smaller operators to get accredited. If we can move on to the next component, this one, a very important one, is the Ministerial Standard for Alternative Compliance Hours. So many of you will be familiar with the current accreditation scheme, which contains basic fatigue management and advanced fatigue management. Under the new scheme, there will no longer be a BFM and an AFM. Rather, there'll just be fatigue alternative compliance. And there'll be a range of opportunities to have different types of alternative compliance. Some of those might be very simple and provide small quantities of additional hours. Others might be such as BFM, and others might be far more complex and similar to AFM. The regulator will be able to develop a set of boilerplate or standard types of alternative compliance hours that people can apply for. And again, they can range to things which are very similar to the current standard hours and provide just small amounts of flexibility through to very, very flexible arrangements. However, there are going to be some outer limits, and there are going to be some requirements on the regulator when approving alternative compliance hours. Now, the outer limits are limits that the regulator cannot approve outside of. So they do act as hard limits. The regulator cannot approve something that is above or beyond what is contained in an outer limit. So let's go through those outer limits. The first relates to the maximum number of working hours, which is 15.5 hours in any 24-hour period. So that's a maximum amount of work. Alongside that is a minimum of 7 hours continuous rest in any 24-hour period. Now, there are going to be provisions for drivers to be able to take a split rest break, and they can split that rest break into two. But there are some limitations on that. So the split rest break can't be scheduled by the operator under any circumstances and can only be accessed by a driver to manage problems with sleep or unplanned circumstances. Split rest break provisions must include a major rest break, which is defined under Section 221 of the amended Heavy Vehicle National Law. And that means when having a split rest break and breaking a rest break into a minimum of two parts, one of those must be at least 5 hours. The regulator must be satisfied that the operator has adequate controls in place to reduce the increased level of fatigue that might result from splitting a continuous rest break. And the regulator must specify how frequently a split rest break can be split. So how often can an operator access a split rest break? So they are the outer limits. And then, of course, the other element to the ministerial standard is the risk classification system matrix. This is a document, or this is a matrix which has been taken from the current risk classification system, and the regulator is required to use that risk classification system matrix when assessing the fatigue risks associated with a particular fatigue accreditation. So we can just move on to the next slide. There's a couple of points I want to make in relation to the split rest break to make sure that those provisions are properly understood. So a split rest break is not an automatic entitlement for a fatigue accredited operator and for their drivers. It is something that an operator has to apply for, and the regulator must approve access to split rest breaks as part of fatigue alternative compliance accreditation. A split rest break can only be used for the purpose of managing sleep or unplanned circumstances, and that becomes quite important when I get to a lower point. The regulator will determine how rest can be split, such as a 6-2 or a 5-3 combination, so splitting rest into a 6-hour block and a 2-hour block, or a 5-hour block and a 3-hour block, how often that rest break can be used, and requirements for managing fatigue associated with that split rest break. The regulator will also be able to limit when a driver may use a rest break. So they may limit access to a split rest when, to circumstances when a driver is on a multi-day trip, but not permit the use of a split rest break if they're doing at-home operations. Now, what that means in practical terms is that a scheduler cannot plan a trip around a driver taking or using a split rest break. All scheduled trips must be able to be completed without the need for the split rest break. So it's important a split rest break sits there as a provision for drivers to manage fatigue, but is not intended to be a tool for scheduling around for the purpose of planning trips. Can move on to the next slide. Some feedback is sought on this one, and there's some very specific points that have been raised in relation to the ministerial standard for alternative compliance hours. First of those, it's been suggested that split rest break provisions should be subject to a requirement that the total of the individual split rest breaks should be a minimum of 8 hours. So as it's currently described, a continuous rest break can be split into 2 parts. A continuous rest break is currently 7 hours, and therefore that would permit a 5 and 2 or a 6 and 1 type arrangement. However, it's been suggested that instead of having the cumulative rest time of 2 split rest breaks being 7 hours, that should be amended to 8, which would therefore mean a 5-2 or a 6-1 split would not be possible, and it would need to be a 5-3 or a 6-2. So the NTC is certainly seeking comment on this particular proposal, what it might mean, the safety implications of it, the practical implications of it. And so very specifically, we're seeking feedback on that particular element. As with other statutory instruments, we are interested in knowing whether the ministerial standard is clear and practical. Is it easy to understand? Do you know what it means? Will it be easy for the regulator to follow? And of course, is the standard consistent with Minister's agreed policy intent? And that might raise a question, what is Minister's agreed policy intent? The agreed policy intent is that the outer limits should be the same as the outer limits for existing advanced fatigue management systems. So with that, I might pass across to Lisa to talk through the National Audit Standard.
Thanks for that, Aaron. Lisa here, Safety Assurance Manager from NHVR. Just to provide an overview of the 4th instrument, which is the National Audit Standard. So this document is ultimately to provide a consistent framework for auditing against the SMS standard and any other of the alternative compliance accreditation requirements. It does incorporate the existing business rules and standards and audit framework and the Auditor Code of Conduct Order of Code of Conduct to ensure that impartiality and independence when undertaking the audits. It also introduces new requirements, which I'll go through on the next slide, just to ensure that we are achieving the safety outcomes, which is one of the intents of all this. So the key features: it defines audit objectives, the methodology, scope, and frequency. It outlines what we require from auditors to be an approved auditor, and it aligns with modern regulatory practices such as ISO 19001, and to ensure audit drives continuous improvements with those safety outcomes. So if we can just move to the next slide. So these are the key changes from what we currently have in place to the new National Audit Standard that we're proposing. The first one is introducing the audit rating of present, suitable, operating, and effective. The intent behind this is to not just check to make sure that systems and processes are in place, but to also go that next step and see that they are effective. So when you undertake an application for accreditation, you'll undertake an entry audit, and as part of that, you'll be checking to see if the systems that are in place are present and suitable. Then when you do that initial compliance audit after receiving accreditation, then be checking to make sure that it is also operating and effective as it's meant to be. We are also introducing minor and major non-conformance. And again, the intent behind this is to really start understanding where we're seeing non-conformances and apply a risk prioritization to them so we can address those major non-conformances, be able to, see them and address them and then also understand what the minor non-performances are to drive that risk-based action. We're also changing the auditor rule from 2 period down to 1 period. So currently auditors can undertake 2 consecutive audits on an operator. We're now reducing that down to 1. And the idea behind that is to really introduce diversity into people seeing an operator system. If we keep having the same people going in and looking at a system, you won't necessarily see everything, and getting that fresh set of eyes really helps us ensure that we are checking all the risks associated with their operations. We're also future-proofing it. So we are enabling a digital audit tool for auditors to be able to submit their documents through the portal. And we're also including some provisions around AI. We understand AI is here. There's some great benefits in using it in the auditing space, but there are also some limitations and considerations that we all need to be made aware of. So it's just outlining what they are. And as I mentioned just on that previous slide, it is aligning with the modern regulatory practices to drive that risk-based approach as opposed to just looking at if they're compliant or not. And we have streamlined those business rules and the audit frame, so the audit framework and code of conduct into that single nationally consistent structure. Before I move on to the next slide, some of the feedback that we're chasing from these is the same as the other documents. You know, is it clear, practical and achievable? Do you know what it means? If you can just go to the next slide. In what we're doing following the consultation is we're currently working on developing our training needs and comms assessment. So understanding who do we need to get the messages out to, who needs to be trained. We do understand this is a different way to auditing to how we're currently doing it. So we want to make sure that the auditors are all prepped, aware and trained prior to kicking off on the 1st of July. So we'll be developing the training program in the new year and then starting to roll that out from about March onwards. And that's it for the National Audit Standard.
Thank you, Lisa, and thank you, National Heavy Vehicle Regulator. We do have a range of options for going into question time now, so we can go into questions. There is a Q&A area and there's also the chat. Both of those are open and we welcome questions from all participants here. Michael McCarthy will be managing that particular process. We do sincerely hope that there are some questions at the moment. And we do have a question that has come through straight away from Jaden Lim through to the National Heavy Vehicle Regulator. How will NHVR ensure alignment of the Safety Management System standard with revised master code, given it's due for publication before the Safety Management System standard?
I'm on the master code panel, so I've been working very closely with that, and that's the current. I just had that conversation with them this morning to do that cross check. So yes, we are looking at that.
So the summary position there is that we're always working to make sure that all of these documents are aligned. So that includes ensuring that the Safety Management System standard aligns with the National Audit Standard, and then making sure that the master code is also aligned with those particular documents. And while we have the opportunity to talk about the master code, one of the features of the new law is that there will be codes of practice, which we developed and approved by the regulator. The existing codes, including the master code, automatically transition across. But as of the future, the regulator will be developing and approving codes of practice. A couple of procedural questions have been asked in relation to, can we get a recording of the presentation? And yes, this will be published on our website shortly. And no doubt we'll be able to make a copy of the slides available also to people that participated. We have a second question from Tess. How will the split rest break work with EWD providers where they are currently unable to program a split rest break into their existing systems and pushing accredited AFM companies to gain reaccreditation to write out the split break? There's a couple of elements there. One of them relates to the various capabilities of EWD providers. What we're trying to provide through the accreditation scheme is to make sure that there is the flexibility that operators need to conduct their operations and most effectively manage fatigue. And where that includes having a split rest break, we want to make sure the law provides for it. The administration of some of these elements is slightly more complex, and the regulator may have some views about the approval of electronic work diaries, but essentially there will always be a need for records to be kept in relation to work and rest hours. There are no provisions in the law to be exempted from having those records of work and rest hours. In many respects, there is a challenge there for providers of electronic work diaries to build in the correct logic so that approved schemes or accreditation options approved by the regulator can be accommodated through electronic record keeping. But those two things are not directly related, in the sense that we want to make sure that the law provides that flexibility first, and then provide opportunities for operators and industry to take advantage of that flexibility. I might just ask if the regulator has any comments in that question in relation to the capacity of EWD providers to accommodate split rest breaks.
Thanks, Aaron. We're looking at that internally at the moment to understand exactly what it's going to be looking like, and then we're going to be working with the currently the 13 providers to go down that path. But what you've said is quite correct. The EWDs, the same as a written work diary, need to be able to show the split rest breaks as required. So it's, for us, it's a case of understanding exactly what that'll look like in the new world order and working with the providers.
Thanks, Paul. I might just go to a question which stays on the topic of split rest breaks. We mentioned that split rest breaks in a 24-hour period, but you mentioned the frequency of split breaks. Do you envisage having a guideline for the number of days in a row this may be allowed and meet any other legal WHS alignment requirements? So in summary, the regulator is expected to put in place limitations on how frequently and what circumstances a split rest break could be accessed. So while it doesn't form part of an outer limit, the risk assessments done by the regulator will inevitably lead to circumstances where it says, yes, you can access a split rest break, but you can only access it once a week, or you can't access it more than one day in a row. And there will be different rules may be put in place for different operators depending on how they manage their fatigue operations. But I'm going to assure you that, yes, there is an expectation that there will be some limitations placed on individual operators, albeit they don't form part of the outer limit. The next question I want to go to is one from Kerry, which is for the regulator. Will there be a closeout period for non-conformances following an audit?
So could you just repeat that question, sorry?
Will there be a closeout period for non-conformances following an audit?
Yes, there'll be 3 months for that one, for the closeout period.
Fantastic. And we also have another audit-related question, also from Kerry. The one audit per accreditation period limits the opportunity of the audit to help with continuous improvement with the operator. So that may be more of a comment, but perhaps there might be some views from the NHVR about how you link those limitations on how frequently an auditor can audit with that need for continuous improvement.
That's good feedback. We'll take that one on board. But I guess we're trying to break up the ongoing the auditors that keep seeing the same operators to increase that diversity. But that is a comment that we can take on board.
Thank you very much. Okay, so there's a couple of questions which are back in the chat, so I'm going to go through those. The first one from Darren, which is a question: does this mean all current NHVAS operators will now need to apply again given the changes? So this gives me an opportunity to talk about transition arrangements. If you're currently an NHVAS accredited operator, when the new law takes effect, you are still governed by your existing accreditation. And you'll be governed by your existing accreditation until one of two things happens. Either your accreditation expires or 3 years elapses from when the new law takes effect. Throughout that period, you will be governed under your existing accreditation. So whatever your existing AFM might be or your existing BFM might be, you will be governed by that. The regulator will be doing some work with operators to, refine the expiry dates for some operators, because obviously we don't want a circumstance where on the first day of the new law, somebody finds that their accreditation is expiring and they haven't had the opportunity to think about what they want to do under the new law. So there will be some work done to assist with that transition arrangement so that nobody loses their accreditation on day one. And likewise, if I can speak for the NHVR, they certainly won't want a situation where everybody has their accreditation ending after 3 years when the new law takes effect. So the regulator will do some work to make sure that there is an orderly transition from people from the existing accreditation through to the new accreditation. And likewise, there will be some form of application process to transition to that new accreditation, because you will need to be able to demonstrate that you have an appropriate safety management system in place. And when you apply and get your appropriate safety management system in place, you may need to apply for a different form of accreditation or a different type of fatigue accreditation, depending on your circumstances. There's also been a question asked about the regulatory benefits afforded to operators through existing accreditation programs. So yes, we've talked about accreditation covering work and rest. What about annual roadworthiness in states that don't require this, where the operator holds maintenance accreditation? That's a really great question. It is the intent for those types of regulatory concessions to still exist and to continue going forward. What that will mean is an operator will need safety accreditation, and the regulator will put in whatever specific requirements might be relevant to vehicle maintenance, and they will work on those specific requirements in conjunction with the relevant jurisdictions that provide those regulatory concessions, so that there is a way of recognising your accreditation and for those regulatory concessions to continue. Now, I've given a very brief answer, so I might, given this will be administered by the National Heavy Vehicle Regulator, pass across to them just to double check that I've described that correctly and give them an opportunity to fill in any gaps I may have missed.
Aaron, it's like you've been working here for many years. That's exactly where we're heading. The maintenance will be maintained by us under the new law, just done as a general safety accreditation, so SMS plus some information we will need for maintenance, so that potentially, well, mainly New South Wales and Queensland can continue to do the exemption of for maintenance across the board. So not much will change in that space, with the exception that once your current maintenance expires, whether it's 12 months in, 2 years in, 3 years in, as the case, you'll need that SMS on top of the maintenance issues.
Thanks, Paul. I might just shift back to the Q&A when we do have a question from Paul Robinson, which is, will the new alternative compliance work rest hours, will those current BFM, AFM certifications still be relevant under alternatives, or will there be a new type training module for this? So I'll try and extract what I think that question is asking. So as I've said before, if you currently have an AFM or BFM accreditation, you will continue to operate under that accreditation until such time as your accreditation expires or 3 year passes. In the lead up to the new law taking effect, and certainly post that period as well, the regulator will have the opportunity to develop equivalents of AFM and equivalents of BFM that you will be able to apply for. So there may well be, the regulator may well develop something that is very similar to BFM, that if you're currently a BFM operator, when you transition, that might be the type of accreditation you want to move across to. So the regulator will be able to develop what we would call boilerplate accreditations for fatigue that people might apply for. That will be easy in the sense that you will know exactly what you need to demonstrate in your safety management system and what kind of controls you would need to have in place to manage fatigue. There might be, and this certainly might be the case for some people on AFM, it might be that there isn't a boilerplate accreditation already in existence that suits your needs, in which case you would work with the regulator to develop your own, or you would put together your own proposal for the hours that you want to have available to you. You would obviously put forward proposed controls, and you would work with the regulator to determine whether those controls and whether those hours are appropriate, and they may be amended, and that will be done through an application process. So that, I hope that covers off your question, Rob. Sorry, Paul. Not anything new in the Q&A, so we'll go back to the chat. There was a comment made again around audits. There are also quite strict requirements relating to consecutive audits and conflicts of interest, not just by the specific auditor, but for any auditors connected to them, e.g. employed by the same company, working relationship with the company. Has there been any analysis into the feasibility of implementing or monitoring this? So I might pass that question across to the regulator. So I think the question here is monitoring those potential conflicts of interest with auditors.
Yeah, so this is something that by digitalising the audit tool, we'll be able to get a greater understanding of analysis of data and getting that data quickly to work out that network analysis. So we have scheduled it into our program of work.
Thanks a lot, Lisa. Got another question from Christine. Many operators have just one module, e.g. MAS. Will they require the SMS in addition? So the answer, the very simple answer to that is yes. As you transition across, you will need to have a safety management system, and that's by design. The intent is that accreditation doesn't just look at the specific benefit you want to get from accreditation, but as an operator, you are demonstrating that you have robust safety systems across all of your business. And so that is the key reason why a safety management system has become part of the prerequisite, so to speak, for getting accreditation. You happen to mention MAS accreditation, so something I will add in here for people who may not be aware of it. But as we go forward, we will be taking away the concessional mass limit, because we are going to be increasing general mass limit up to the existing concessional mass limit. So there is a piece of work underway to increase allowable mass limits from GML up to the existing CML, so increasing general mass limits up to the current concessional mass limits. And for that reason, there won't be a separate mass accreditation. However, as with maintenance, there will still be a need to be approved by the regulator to access higher mass limits. So again, the regulator would administratively have a form of safety accreditation with a specific focus on mass management, so that you can get that approval to operate at HML. Before I flip across to the Q&A section again, another one in the comments section. And again, this will be for the regulator. You mentioned digital audits. Is this going to be facilitated on the NHVR portal? Are there alternatives?
So I can take that question. Yes, the intent is it will be on through the portal. We obviously will have a paper version as well that could be used if there's no internet connection. That said, it must be submitted through the portal.
Thanks, Lisa. Heading back to the Q&A section here. Great question from Kerry. Must every operator have general safety accreditation if not seeking alternative compliance accreditation? In reality, you only need to get that general safety accreditation if you want to be an accredited operator. You do need general safety accreditation if you want to access fatigue management, alternative accreditation in fatigue management. But as we've mentioned, general safety accreditation will also be necessary if you want to get those vehicle maintenance concessions from state road jurisdictions. And similarly, if you want to access higher mass limit, you will need to get a general safety accreditation. Now, there may also be advantages in getting general safety accreditation in order to demonstrate to suppliers, customers, etc., that you have a benchmark level of safety management in your business. But again, that will be a matter for the market rather than for the NHVR or the system, so to speak. So just having a look here at another question from Tess. Is there an idea of what the fatigue management systems will look like for companies' drivers operating vehicles under 12 tonne? So I might pass across to the regulator for some elements of this, but in essence, there is still a requirement for all drivers of heavy vehicles not to drive if they're fatigued. In fact, one important change in the law is that the duty for a driver not to drive while fatigued has been extended from drivers of fatigue-regulated heavy vehicles to include all heavy vehicles. So there will be a requirement for drivers of vehicles under 12 tonne not to drive while fatigued. And I should say they also need to be fit for duty when driving, and that also includes for vehicles under 12 tonne. There isn't a requirement necessarily for the same record keeping. They're still limited to fatigue regulated heavy vehicles. But in case I've missed something important in that space, Paul, I might just pass across to the regulator if there's any other comments around what fatigue management systems will look like. And I think the answer I'm really giving is that they will look the same as they do now, apart from the expansion of that duty to not drive while fatigued. But Paul, is there anything else, or across the NHBR, is there anything else that I might be missing there?
No, there's nothing missing that I've heard you say. The only other thing is, because this is all fairly new, that between now and 1st of July, certainly early into the legislation going live, we'll be providing guidance, material, and regulatory advice on how you get into that. The fatigue management systems, though, no, they won't change a hell of a lot in that space, but the nuances of unfit to drive, and there's a lot of we need to remember that has been in the workplace health and safety law for the last decade or so in a very, very similar format. But we're going to provide some guidance for operators and drivers as to what does that mean? What does that mean on the side of the road? What does that mean as you wake up for work that day and have a screaming migraine? Those sorts of things.
Thanks, Paul. A question from Raquel. Will there be a transitional period for these changes to the law and instruments? So the answer to that is we're expecting after the law passes, and we're expecting the law to pass later this year. We're expecting that the new law won't take effect until sometime in the early part of the second half of next year, so July, August type period next year. So that means there's going to be a period of around 6 months of a transition arrangement, so to speak, or 6 months before that new law takes effect. And that gives opportunities for these statutory instruments to be finalised. It gives an opportunity for the NHVR to work on systems and processes, etc., to be able to make sure the new accreditation scheme can be administered. And of course, an opportunity to educate industry on some of the changes that are taking effect. And as I mentioned previously, for individuals who are currently accredited, there is separate transition arrangements for their accreditation, such that they will continue after the new law takes effect until their accreditation expires. Question from Jaden. How will these changes to fatigue translate to mandatory units of competency required for accreditation? I might pass that one across to the NHVR.
Thanks for that, Aaron. We've already advised Industry Skills Australia that there will need to be a change to, I know it's TLAF 005 and there's another one, I think it's 06. There will be a need to change for the new law. At the moment it's advice, but once we know exactly what's in the standards and the guidelines as we know it, we'll work with the ISA to develop the not the unit of company itself, but the framework of what needs to be achieved, and then we'll let the RTOs sort out what needs to be in there. But as we have been doing for some time, we do regularly audit RTOs on their units of competency that relate to our legislation. So we'll be working with RTOs over probably the next few years to ensure that those units of competency now point to the right direction.
Thanks, Paul. I'm going to shift back to the chat. Got a question from Darren. What about operators that have already an approved AFM accreditation through the NHVR? Given the expected changes with split rest, which won't be part of the current accreditation, does this mean a reapplication on expiry of current certificate? I think the bit to note there is that for all operators or all existing accredited operators once their accreditation does expire after the new law takes effect, there is going to be some form of application process. And again, the nature of what it is you might be applying for, will be determined by your application and what it is that you're applying to achieve from the NHVR. So yes, all operators, all currently NHVS accredited operators, at some point will need to apply if they want to remain accredited under the new scheme once their accreditation expires. We also have a question from Andrew in relation to auditing. Have considerations been made for the number of qualified registered auditors currently available and how this pool can be maintained moving forward?
Yep.
Paul.
Sorry, I can take that one, Paul, if you want.
Yep,
Lisa. So we do undertake analysis of our current auditor pool and ensure that we are planning for the future, which is one of the reasons why we've changed the requirements of the National Audit Standard to open up the pool of applicants to a broader range as we do move to the SMS standard. But it is something that we do monitor, and as part of our annual program of work, we plan for the future and understand what those requirements might be.
Thanks a lot, Lisa. Now, I think we've kind of... no, we do have some new questions in the Q&A section. Just for interest, are you able to indicate roughly how many accreditations does NHVR manage? NHVR.
Yeah, there's currently about 9,500 accreditations across the complete gambit at the moment.
Thanks a lot, Paul. Okay, we seem to have come to the end of the questions in the chat and the Q&A. So we'll just sort of delay or keep speaking just for a moment or so to give an opportunity if anybody does have a final question to get it into the chat or the Q&A session now. As I said before, a copy of this presentation will be posted to our website, so you'll be able to review that. Obviously, our website also has all the consultation documents and the various documents we want you to read, so we do encourage you to have a look at those. We do need your feedback. For things to work well for industry, we need to know what industry is thinking, and we need to know what might be in those documents that give you a question or give you a reason to have concerns or have questions, so that we can then either address those or adjust our instruments accordingly. So as far as I can tell, Michael, I don't think we've had any new questions in either the chat or the Q&A.
No more, Aaron.
Thank you very much. In that case, I'd like to thank everybody for attending today. Very much appreciate you taking the time out of your day. I'd like to thank Lisa and the team at the National Heavy Vehicle Regulator for making themselves available also. I wish you an excellent afternoon and look forward to receiving your feedback and questions as we go through the consultation process. Thank you very much.
Thanks, Aaron.